on the record in 2006131. I want to start by acknowledging an opinion from the Supreme Court of Texas delivered this afternoon, denying the writ of mandamus which was filed by the defendants in this matter. You're not going to need that. Yes. One second, please. It reads in salient part, Constitution is not suspended when government declares a state of disaster. In the weeks since American governments began taking emergency measures in response to the coronavirus, people of this country have graciously and peacefully endured suspension of their civil liberties without precedent in this nation's history. Nearly everywhere, the First Amendment rights of people to peaceably assemble have been suspended altogether. Tens of millions can no longer earn a living because the government has declared their employers or businesses non-essential. Those who object to these restrictions should remember they were imposed by duly elected officials vested by statute with broad emergency powers who make difficult decisions under difficult circumstances. Any government that has made grave decisions to suspend liberties should welcome the opportunity to demonstrate both to citizens and the courts that its chosen measures are absolutely necessary to combat a threat of overwhelming severity. Ideally, these debates would play out in the public square, not in courtrooms. No court should relish being asked to question the judgment of government officials who were elected to make difficult decisions in times as these. However, when properly called upon, the judicial branch must not shrink from its duty to require government's antivirus orders to comply with the Constitution and law, no matter the circumstances. This original petition, that is, the petition challenging this court's right to proceed, which challenges several local officials' virus response measures, must be presented to the appropriate district court. The petition for mandamus is denied. Moments ago, Governor Greg Abbott ordered that among services which were going to be allowed to be open would include, as of May 8th, barbershops and cosmetology salons, which takes care of a part of the issue before us. In Dallas County yesterday, there were 237 new cases of COVID, a total of 4,330 in our county. 77% of the hospitalizations are people in designated essential businesses. That's what we face now. We will continue to face this until a cure is found, or we are all immunized, naturally or otherwise. Until that time, it is imperative that the instructions of our elected officials from the state capitol to this courthouse are respected and followed. Failure to do so will only have catastrophic consequences, and those reach far beyond the exigencies of one family or one business. In Luther, there may be circumstances which you genuinely believe are acute. You may believe that these mandate your actions in open, direct, and notorious violation of the orders promulgated by our elected officials. Hopefully, this experience has brought you to the realization that because you believe there's something you want to do, you do not have the right to independently supersede state law. A determination has been made that you are in contempt of this court. You refuse to shut down your business in the face of a restraining order which required you to do so. You continue to operate your business for a full week, even after being ordered not to. Earlier, reference was made to your having keys to the jailhouse. You may utilize them now. If you would like to take this opportunity to acknowledge that your actions were selfish, putting your own interests ahead of those of the community in which you live, that they disrespected the executive orders of the state, the orders of the county and this city, that you now see the error of your ways and understand that the society cannot function where one's own belief in a concept of liberty permits you to flaunt your disdain for the rulings of duly elected officials, that you owe an apology to the elected officials whom you disrespected or flagrantly ignoring, and in one case defiling their orders, which we now know obviously apply to you. That you understand that the proper way in which in an ordered society to engage concerns which you may have had is to hire a lawyer and advocate for change, an exception or an amendment to laws that you find offensive. That you publicly state that this is the way that citizens in the state should behave. And that you represent to this court that you will today cease operation of your salon and not reopen until after further orders of the government permit you to do so. This court will consider the payment of a fine in lieu of the incarceration which you've demonstrated that you have so clearly earned. Is there anything that you would like to say? You must stand up if you speak in this court.
Judge, I can't hear. I cannot hear her.
Can you assist us? I know, we're trying to find it. Oh.
Judge, if you'll mute yourself, please. If she's talking, I'm not hearing her.
Hang on just a second, ma'am. Just say a few words. Give us a test.
Test.
Yes.
Better?
Better.
Okay, you may proceed.
Judge, I would like to say that I have much respect for this court and laws. and that I've never been in this position before, and it's not someplace that I want to be. But I have to disagree with you, sir, when you say that I'm selfish, because feeding my kids is not selfish. I have hairstylists that are going hungry because they'd rather feed their kids. So, sir, if you think the law is more important than kids getting fed, then please go ahead with your decision, but I am not going to shut the salon.
Earlier, I stated findings and conclusions that I made with regard to this matter. It is hereby ordered, adjudged and decreed that defendant Shelley Luther, having been found in criminal contempt of this court, is hereby remanded to the custody of the sheriff of Dallas County as punishment for her violation of this court's order. Defendant Luther shall be confined to a penal facility of the choosing of the sheriff of Dallas County, where you will remain for a period of 7 days, 1 day for each day that you violated this court's order. It is further ordered that the defendant, having been found in civil contempt of this court, shall hereby be remanded to the custody of the sheriff of Dallas County as punishment for your failure to comply with the order of this court. Defendant Shelley Luther shall be confined to a penal facility of the choosing of the sheriff, where she will remain for a period of 7 days. It is further ordered that the penalties, both civil contempt and criminal contempt, shall run concurrently. It is further ordered that defendant S&B Hot Mess Enterprises, having been found in criminal and civil contempt of this court, is hereby ordered to pay a fine of $500 per day for the 7 days in which it has remained in business, and will be paid within 30 days of the date of this order. Further ordered that defendant Hot Mess Enterprises, having been found in civil contempt, is hereby ordered to pay a fine of $500 per day for each day from this day going forward in which the salon remains in operation through May 8th. Sheriff, take this defendant into custody, if you please. An order of judgment of contempt and commitment will be online directly. Anything further from the city? Anything further from the defense? Thank you very much. We are in recess. You are all excused.
Live stream off.